Several new rules of law to read today, in addition to the note cards that we read yesterday. Let's start with what's in front of our faces. This is going to be part one of, like midterm review of torts, and we're going to try to focus on the elements and get right through it. So we'll start with the definition of intent, which is characterized as a volitional act, which is voluntary, which is on purpose, and it consists of knowing with substantial certainty that a result will occur from the Garrett case. And that is one other way that it's characterized. So a volitional act, voluntary, on purpose, alternatively, knowing with substantial certainty that a result will occur. Intended contact that was offensive or harmful. Good faith mistake, which means you don't have to have an intention to harm, from the Ranson Act. Mental illness does not negate intent, from the McGuire Act. And transferred intent liability, intended to act, from Talmadge, the Talmadge case. So transferred intent to harm A and you actually harm B, you are still liable because you did intend to volitionally act out of volition. Apply that to battery, our next rule. Intentional touching in a harmful or offensive way or manner. Again, the elements are an intent to touch, an intent to harm, an actual touch, and actual harm. Touching means or is satisfied by contact with items that are so connected with the body as to be customarily regarded as part of the other person. And this is from the Fisher case. And touching, even as small as a particle of cigar smoke, can constitute a touch. So the rule for assault is that the defendant acts to place the plaintiff in apprehension of imminent offensive or harmful contact, and apprehension occurs. In false imprisonment, the rule of law is an unlawful restraint through force or threat of force that confines someone to a bounded area. The minority rule expressed in their statement is that this confinement must be for some time, and awareness by the plaintiff is sometimes required, which is the case which is from the Harvey case, which is in, I think, New York, but it is a minority rule. Moral persuasion is not enough to be force, which we know from the Hardy case. That's the case I referred to the other day with the ship bringing a female to America and not giving her a rowboat. No, I'm sorry. Hardy is thief. Okay. The defendant who has a duty but doesn't provide a means to leave has confined them. That would be your rowboat case. Intentional infliction of emotional distress. The rule is that the defendant acts intentionally or recklessly, and defendant's conduct is extreme and outrageous, and the conduct must cause severe emotional distress. Conduct so outrageous, a reasonable person would be caused severe emotional distress, and mere emotional distress is not enough. For a third party, intentional infliction of emotional distress expressed in the Taylor case, the defendant must intend to cause emotional distress, and the defendant must know that severe emotional distress was substantially certain to be produced by their conduct. Damages are nominal, compensatory, and punitive. Nominal vindicate the rights of the plaintiff, but may only be in the amount of $1. Compensatory restores the plaintiff to the pre-injury status as far as possible. And punitive, to punish defendant and deter others from doing similar bad conduct. And also requires that compensatory damages have been already awarded. Guidelines for the calculation of damages. We talked about the maximum recovery rule, and the judge may adjust if the jury is unfair. There's 5 cardinal elements of damages we discussed. There's 6 from the Richardson case. A remitter is going to reduce the damages if what the jury awarded shocks the conscience. That appears to be from the Richards case. A trespass to land is every unauthorized entry into the land of another. A mistake is still a trespass. That's from the Dougherty case. And a trespass can be the air above or the ground below the property, which is from the Heron case. I think you're shooting bullets above someone's property, landing on the property, and entering the land with permission but failed to leave is a trespass, and that's from the Rogers case. This is defined in Restatement, section 158. Next page, reviewing definitions, brings us to trespass to chattels from the Restatement section 217. The defendant must intentionally dispossess another of chattel or use or intermeddle with the chattel in the possession of another. Interfering with the possessor's business also can constitute a trespass to chattel, and that was the CompuServe case we discussed. Conversion, alternatively, in Restatement section 222A, which is right after 217 here, is the intentional exercise of dominion or control over a chattel, which so seriously interferes with the right of another to control it that the actor may be justly required to pay the other the full value of the chattel. Okay, so punitive damages, again, is to punish the defendant, to admonish the defendant not to do it again, and to deter others from following defendant's actions. Privileges include consent. Consent can either be expressed or implied. Implied is the O'Brien case. Consent is implied to conduct within the rules of the game, but not to conduct outside the rules of the game. That's the Hackbart versus the Cincinnati Bengals case. Unconscious intent is not implied unless it is an emergency. So that would be your plaintiff is unconscious. In the Moore case, his intent to be cared for is not implied unless it is an emergency. So Moore is probably the ear case that I discussed. Consent obtained by fraud is not valid consent, and that would be the DeMay case. Self-defenses include the existence. Self-defense includes a couple of elements. The existence of a privilege is reasonable force under the circumstances. Retaliation, reasonable belief that you're in danger. Provocation under ordinary circumstances. meaning words are usually not enough to substantiate self-defense. To amount of force has to be reasonable as it appears necessary according to your reasonable belief. So reasonable under circumstances. You can't shoot somebody who's coming just to hit you with his hand. And standing your ground is opposed to taking to your heels. An injury to third party. Transfers the self-defense privilege ought to protect you if in the protection of yourself you cause injury to a third person. The defense of property is that rule is that once one can never use deadly force to protect his property unless the defendant is committing a felony of violence or endangering human life. For the recovery of property, we're talking chattel probably, the plaintiff may use reasonable force to recover immediately after dispossession. However, the party may not use force to recover if any time has elapsed. So this has to be immediate. There is no element of unnecessary violence. So you have to use reasonable force. Unnecessary violence doesn't fit. And the shopkeeper's rule discussed earlier is that the shopkeeper may detain for reasonable investigation a person whom he or she reasonably believes to have taken chattel unlawfully. This is the Bonkowski case. Sometimes extends to premises and immediate vicinity of the premises. I think that always applies. And this comes from the restatement, section 120A. Necessity is public or private. Public was demonstrated in the Sirocco case. Private rights overruled by interests of society. So this could be a right where Sirocco, I'm just trying to remember the Sirocco case, but this could be your private right is to have your house not be burnt down by a public official, is overruled by the interest of society if we're blowing your house up in order to contain a fire that is threatening to set the entire city on fire. Private necessity, one would not be liable. However, you must pay the damages. So in the Vincent case, I think we saw that a ship could not be sailed in certain weather, and so it was docked at a marina, and the marina suffered damages by the ship because of the degree of severity of the storm. And so he who docked his ship at the marina pays the damages of what his ship did to the owner's property. But he's not like liable for a tort, I guess, per se. Only the damages. So anyway, justification is another, I think, defense. So the defendant's actions may be justified in the action if the actions taken were reasonable, done to protect others from personal injury or to protect property. So we can move into negligence now. Duty is reasonable care under the circumstances from the Blythe Act. Foreseeability is defined in the Piper Act. The risk-cost-benefit analysis factors come from Crayon and Learned Hand's risk-utility balancing formula comes from the Carroll towing case. That's the burden being less than the probability of risk and the cost of the loss. The breach of the duty is the second element of negligence. Causation is the third element of negligence. Cause and fact and proximate cause establish causation. And damages is the fourth element of negligence. In the risk-utility balancing formula from Carroll towing, the cost of but for the precaution, the injury would not happen. To act without precaution if the burden is less than the expected cost. So again, the burden is less than the probability times the cost. What is the cost of the safety precaution compared to the loss and probability of the loss? The plaintiff will argue, but for the cost of a $5 sign, this horrible accident would not have occurred. And I'm showing you the formula. Trespass to chattels, restatement section 217. Nope, don't have to read that again because we already read that. Standard of care for negligence is, the defendant would argue here under the risk utility balancing that, but for a $1 million overhaul, this minor accident would not have happened. So trying to show that the burden, what the burden translates to relative to, like, say, its benefit or its prevention of the risk of harm. Standard of care is that which a reasonable, prudent person would observe, and so what a reasonable person would have done under the circumstances is how you define standard of care. You must use a reasonable care under the circumstances is the requirement. The test must be objective, it can't be subjective. That was established in a Vaughan case, which may be like 200 years old, involving combustible straw or whatever. Have knowledge that a reasonable, prudent person would have, which comes from McAdoo, and that tends to be a community rule based on where you live. Your knowledge base should be generally based on where you live. You may not have any experience driving in snow if you're from California. I don't know. Evidence is the custom or industry norm. So that is admissible evidence, but it might not be conclusive from the Tremarco case. From the Tremarco case, also, standard of care is relevant to time, place, or person. And an emergency, which is not of one's own making, a standard of care, reasonableness in an emergency, we might be a little bit more lenient on what's reasonable in emergency. However, you cannot have put yourself at peril. Physical characteristics can be taken into account, seeing the Roberts case. Minors and children, reasonable child of like age, intelligence, maturity, training, and experience is generally the standard of care that children are held to, unless they're involved in inherently dangerous activities such as like snowmobiling. Mental illness is not considered when determining the standard of care, shown in the Brewing case. Standard of care for professionals. The same standard of care as the ordinary member of the profession under the same or similar circumstances comes from the Heath case and is not adjusted for particular training or experience of an individual and is higher for those that hold themselves out as a specialist. Mere error in judgment that results in bad results for client does not constitute negligence, and expert testimony is required to establish a standard of care in professional malpractice from the Boyce case. The only time that goes away is when it's obvious because there's like a sponge inside of somebody's body that negligence occurred. National certification for board-certified physicians, hospitals, medical laboratories, and other healthcare professions is a nation standard from the Morrison case. But in the minority rule, some jurisdictions go by a locality rule that the physician doesn't have to follow the national standard if he wouldn't know it because he's in such a remote area that maybe he doesn't have access to that knowledge base. Informed consent, material risks. What would a reasonable patient want to know about the nature, consequences, material risks, and possible alternatives to treatment? So the physician is responsible for communicating material risks to his patient, must inform his patient of material risks. The majority rule is that the physician focus standard, meaning or requiring that a physician inform a patient of the risks that a reasonable physician would have. In the minority of jurisdictions, there's a patient-focused standard which would hold someone to the standard of providing what a reasonable patient would want to know before consenting to a treatment, and that comes from the Scott case. Under informed consent, the doctor is required to disclose his or her own research or economic interest in the patient's treatment protocol under informed consent, and that's from the Moore case where this guy's genes were used for research and they just kept asking him to come back and for more treatment without telling him that his genes were so profitable. Okay, negligence per se. In order to determine whether a standard of the statute can be used to establish standard of care in the negligence action, the judge must determine the party seeking to prove the violation is a member of the class the legislature intended to protect, and the hazard or harm that occurred was one the legislator intended to protect against, and the risk against which the legislature intended to protect against. This is important for negligence per se. Furthermore, the duty and breach established by law is you're trying to prove to the jury that the duty was established by law and the breach occurred, but only the jury determined. But then the jury would be left to determine only causation and damages elements under negligence. And criminal statutes cannot be used to establish negligence per se. That's kind of not true. The effect, but the teacher wrote it, so it's true. The effect of the statutes is, in the majority of jurisdictions, is that an unexcused violation of the statute is negligence per se, and that's from the Martin case. In the minority of jurisdictions, a violation of the statute is provides a presumption of negligence, but is rebutable. And some jurisdictions will allow negligence per se as evidence of negligence, and the jury can decide. I think that's what most jurisdictions are allowing. And an excuse as a defense. The person whose conduct is being evaluated is permitted to show that he or she had an excuse for the conduct that violated the statute. That's from the Zenny case. Excused violations are covered in the restatement, section 288. So that's what we reviewed before the midterm. Took us like a half an hour here. Very good. Let's take a break.